services provided, and any steps that might be taken to transfer the business to another company such that those services would not attract royalties would no doubt provoke a claim that one was in breach of those obligations. So not only is it unclear what routes there would be to winding up the company, it's unclear that one could make any arrangements to transfer the business in any circumstances. Does that answer my Lord's question?
It does.
The other clauses that I should perhaps just draw attention to, there's clause 7.2 on page 139 of the core bundle indicates that the licensor shall have the conduct of all proceedings, but the licensee shall bear the costs of any proceedings. Not perhaps the most significant provision for our purposes, but striking, bearing in mind that this is a non-exclusive license.
So I should, on the topic we were on earlier, I should have asked you about 3.4 as well. The licensee and its group companies shall not do or omit to do any act that will or may weaken, damage, or be detrimental to the marks or reputation or goodwill associated with them. Is that another clause which would mean that, as you would put it, it might give rise to a claim for breach if there wasn't promotion of the brand?
In short, my Lord, yes. Yes. It could certainly give rise to such a claim. In the context of an agreement which is terminable, there is nothing exceptional about that. But it is in combination with its possibly not being terminable that the problems arise. Clause 4 is perhaps in some ways even broader. Clause 4.1, the licensee and its group companies should comply with the specifications, standards and directions relating to the licensed services. So there's an obligation basically to run the business according to the direction of whoever happens to be your licensor at the time, not simply confined to the services under the mark, but services generally, including services provided by any other companies under the mark.
And including in relation to the use of the mark?
Including in relation to the use of the mark, but not confined to in relation to the use of the mark, and including directions that one may be given by a competitor who is using the mark, since, of course, this is a non-exclusive license, and there would be no basis on which, at least as a matter of contract, we could object to a competitor using the mark and being in the position of our licensee.
That's not a best endeavours obligation. That's expressed as an absolute obligation. Would that entitle the licensor to direct that certain things must happen in relation to the use of the mark in the manufacture, promotion, distribution, and sale?
But the short answer, my Lord, is of course yes. I mean, there may be some scope for arguing that such powers are to be interpreted in the sort of spirit of Product Star and the Braganza line of authorities, and that such provisions can't be used perversely, but on the face of it, it is a power to specify standards and directions, and there would be an absolute obligation to comply with it.
So if a direction was given that every building should have on every piece of door furniture and bathware in bold letters, Zaha Hadid, there would be an obligation to put that on every building that the company was involved in designing.
Lord, subject to the caveat that I expressed earlier as to whether one could say that it was in some way an abuse of the power, the answer is yes. It could depend, but it is undoubtedly a far-reaching power that the licensor would have to exercise control over the conduct of the business.
Mr. Block, an example where this sort of thing would be perfectly normal and would involve competitors would be franchising.
Yes.
In which, dare I say, McDonald's would almost certainly have a contract with a clause like this in it, and could very well say to all its franchisees, you now need to change your McDonald logo from this to that, and you need to put it all in the thing. And the fact that your two McDonald'ses are 5 miles apart down the high street and to some extent competing is nothing to do with it. So there's nothing odd about an obligation of this sort in a trademark licensing context, but I understand your submission.
Yes.
You say that the issue is the termination.
Lord, yes, and indeed, without taking my Lord's analogy too far, I mean, in the context of a franchise agreement, there will normally be specific provisions relating to how closely to the particular franchised outlet it will be appropriate to.
Absolutely.
And provisions of that kind. But yes, there are contexts in which one would not object to any of those clauses. It's their combination and in combination with the termination provisions that the issue arises. And indeed, if one jumps forward and considers the restraint of trade case, we will of course acknowledge that license agreements are part of the trading society, if that's the right way to refer to it, and that again, if one puts to one side the question of the term of this license, the terms that we have just been looking at do not themselves, are not themselves out of the norm or exorbitant, because one will have the opportunity of terminating the license, be it specifically under a period of time under the contract or reasonable notice, if one does not wish any longer to conduct one's business on those terms. The last term I would take the Lords to before the termination provisions of themselves is 11.2. That is on page 141 of the bundle, and it just makes good the point that I was making in relation to assignment, and therefore the lack of any comfort one might get if one were to get it from the fact that the licensor was originally Dame Zaha herself, who of course could not continue in perpetuity and is currently the foundation. Clause 12 is the principal focus of dispute. That's at page 142. The company contends that the express provision that the license agreement shall continue indefinitely in clause 12.1 means that it continues unless terminated on reasonable notice. Whether that is right or wrong, of course, depends on the proper application of the principles of contractual interpretation. As the judge noted at paragraph 137 of his judgment, we do not contend for an implied term. However, we do rely on considerations of commercial common sense, and there is obviously a close overlap between the factors which go to business efficacy when considering the implication of terms and those that go to commercial common sense when interpreting express terms. With that introduction, I was proposing next to go to the principles of interpretation, which will of course be all very familiar to my lords, and I will endeavour to deal with that speedily.
I'm sorry to slow you down, but can I just ask you about one or two other terms?
Of course.
First of all, clause 6, which provides for the 6% royalties, has at 6.7, the provisions of this clause 6 shall remain in effect, notwithstanding termination or expiry of this agreement, until the settlement of all subsisting claims by the licensor. And I have two questions. First of all, does one find anywhere else a provision that after termination by the licensor, the royalties will cease? The obligation to pay the royalties will cease.
I don't believe there is any such specific provision.
And do you say that that is what this 6.7 means, or is it the position that, at least arguably you would say, the structure is that the royalty is payable for as long as it's payable, notwithstanding termination by the licensor?
I confess that it's not a clause that I have focused on especially. On one reading, and it may not be the correct reading, but I think it was probably my initial reading, it was simply a concern to ensure that the right to recover the royalties were payable in respect of services during the term would be recoverable after it.
Yes.
On a second reading, it is in effect saying that royalties will be payable for a longer period where there are outstanding claims. So it is a commercial encouragement to ensure that there are no outstanding claims following the termination of the license, or as it might be seen from the perspective of the licensee, a penalty. But whilst it is perfectly true, of course, that it contemplates termination, it is capable of applying where the termination is, for example, for breach by the licensor and notice given under clause 12.2 by the, breach by the licensee and notice given under 12.2 by the licensor. So it was not something which, at least to date, and subject to my lord drawing this to our attention, we thought assisted in relation to whether or not there was a right under the agreement to terminate.
Right. Then the other question I have is that this is expressed in terms notwithstanding termination or expiry of the agreement, and we get the same in 13.1 on expiry or termination of the agreement for any reason, and the consequences are then set out. What are, on your case, are circumstances in which the agreement might expire rather than terminate?
it is unclear that there are any circumstances in which it can expire, save insofar as it may be terminated by one party or another. What this may indicate, and which I think we would submit it does indicate, is that there are a number of clauses in this agreement which, whilst it has been drafted professionally and includes much detail, may not have been tailored to the circumstances of this particular license with any great care. And one can envisage circumstances in which we no longer require architecture or something, which would be somewhat fanciful. It may indicate no more than that the draftsman finds two words or better than one in circumstances where in fact that is not an appropriate way of drafting.
Thank you. Mr. Lord, can I just put one point to you which arises out of a question my Lord asked you about the possibility of what you might call post-termination royalties being due forever, as it were. I wonder whether the definition of licensed services might also suffer for the same infelicity that you've just been describing, because one might have thought that once the license had come to an end, whatever the services were, they weren't licensed services anymore because they weren't licensed and therefore didn't attract a royalty once the contract had come to an end. Now, I am putting words which are not there because although that's what you might think the word licensed services meant, of course it's a defined term which doesn't include within it expressly the words I've just put to you, but I just wonder whether that might be another example of what you've just been putting.
My Lord, yes, and of course one of the issues when one is seeking to construe an agreement is the extent to which one can read into clauses of this kind the additional words without which it would make no commercial common sense, and would certainly say that it is no part of our case that in the event that the license were to be terminated, we would have to continue to pay royalties indefinitely, or that we would have an obligation to continue to promote the licensed services indefinitely, not least because we wouldn't have a license insofar as they related to trademarks to do so. But it is, with respect, I would agree with my Lord and Lord Chancellor, another example of what the judge referred to as what may be somewhat inelegant drafting, and that is something which we rely on when we say that insofar as the language may be considered not entirely apt to support our case, there is scope here for reading it in a way which makes good commercial sense.
One more question, if you be so patient. You were about to take us to principles, but you were disavowing any attempt to imply a term.
Yes.
And I'm asking you because I don't know whether you will ever return to that subject at any point, having disavowed it. But if we look at what your plea for relief was, 116 of the details of claim, bottom of 116, top of the following page. Your submission is that your first case is an exercise in construction and not of implication, is it?
Yes.
And just in layman's terms, before you get to the principles of this, why is that?
We say this is an exercise in construction rather than implication because what we are concerned with here is the language of clause 12.1 itself and the meaning to be attributed to continue indefinitely in the context of that provision.
Putting it another way, what's wrong with implication? Is it because it's hard to do? Is that why you don't put it in that way? Because look, I'm bound to say, at my greater distance from these matters, it looks a lot like implication.
We do maintain, of course, that it is necessary that this agreement be terminable if the agreement is to have business efficacy. And to that extent, we have the basis on which to argue that there is or should be a term implied into this agreement to that effect in the event that there is no term. But we also acknowledge that there is an express termination provision in this case, and that meaning needs to be given to it. If that provision has a meaning which is consistent with the implied term for which we would be arguing.
So if you have to argue for an implied term, you argue for it.
Lord, we haven't argued for an implied term.
Right. Well, I mean, this may be an important point. So I'm in a sense offering you the possibility of an implied term. At the moment, you're rejecting it.
But Lord, it's not something that I can possibly reject, but I must acknowledge why we have put our case as we have done, and perhaps identify a potential third position. On the one hand, one says we are concerned with the construction of the express termination provisions, and they, on one view, endeavour to, or appear to, provide a complete set of provisions relating to termination. On another view, one says, whilst there are a set of termination provisions, they don't expressly purport to be the only basis on which the license could be terminated, and consequently there is scope for implying a term that the license can also be terminated on reasonable notice.
My last point is to do with B on the following page.
Well, before getting to B, can I just say that there were three options,
I beg your
and
pardon.
I've only given you two of them.
I'm sorry.
The third option is that on the proper construction of clause 12.1, it is envisaged that the license is terminable because it only talks about the license continuing indefinitely, and you resort to implication in order to determine how it is to be determined in those circumstances. So you say there is a right to terminate, what is the extent of it? And if one looks at the license cases, reasonable notice comes in there, not so much as providing an additional right to the person who wishes to give it, but in the context, for example, of the Winter Garden Theatre case, is saying you can't terminate without giving reasonable notice. It's the restraint rather than the right which is implied. Sorry, Lord, I interrupted.
No, just to finish on B. This is an assertion that its clause is unenforceable for restraint of trade. Why does one then go on to do something which is described as modifying? It may be that this is
familiar territory, but not to me. What is going on when one modifies something? Don't you just simply say it's a restraint of trade? Why do you have to go on and suggest something that looks to be the implication of the words in bold into the contract?
My Lord is quite correct with respect. If there is no way, either under the contractual provisions which provide for modification and severance, or as under the general law, to cure the restraint, the agreement is unenforceable as a whole. And we could have gone straight to that. We accept, however, that where there is a way to cure it, that is the proper thing to do. And it's that which we have addressed in that part of our pleading. But as a matter of law and matter of, as it were, the default position, if there is no cure, the agreement as a whole is unenforceable.
Right, so you haven't simply said it's unenforceable. You want it in a different form, which you've clearly set out.
My Lord, we may have conceded too much. What we have acknowledged there is that the court is likely to look, and in the ordinary way, the other party would be likely to seek to make the minimum changes necessary, and we have set out what we see as a potential change that could be made there. But plainly, if the court finds there is that the agreement as a whole, as it currently stands, offends the doctrine, and it finds that there is no way of curing that, be it by modification or severance, then the agreement as a whole is unenforceable.
Thank you.
My Lords, if I may then turn to the question of principles of interpretation. They are, of course, familiar to my Lords, and I would seek to take them, begin by referring to a convenient summary which one finds in the judgment of Lord Justice Snowden in the Ventura Capital and DNA Nudge case, which is in the authorities bundle, the second volume, behind tab 27 at page 957. The case concerned the interpretation of a provision of the articles of DNA Nudge, under which it was argued that an investor majority might deprive the preferred shareholders of the special rights attaching to their preference shares. The judgment is delivered, main judgment is delivered by Lord Justice Snowden. Lord Justice Bean and Lord Justice Arnold concurred. The relevant section starts at paragraph 38 on page 969. Lord Justice Snowden cites the celebrated passage from Lord Hoffman's speech in ICS and West Bromwich at paragraph 38. At 39, he refers to its endorsement by Lord Neuberger. One notes in particular in 39 and the reference there to the similar statement made by Lord Hoffman in the Chartbrook and Persimmon Homes case, the combination of the things that one has to look at, the reading of the relevant words in their documentary, factual and commercial context. In the part of the judgment in this case, dealing with restraint of trade, at I think paragraph 72 and 73, the judge considered that the court should not be drawn into considering the overall commercial reasonableness of the agreement before it. That there may be a sense in which this is, of course, correct. However, it is also true that it is obviously wrong if insofar as it suggests that the court cannot have regard to commercial common sense. Indeed, there is a line that needs to be drawn there, and not one that is always easy to draw, as one notes from the observation of Lord Justice Snowden in paragraph 40. The task of giving effect to the natural and ordinary meaning of the words used by the parties, whilst also having regard to commercial common sense, having caused considerable debate in the authorities. He goes on then to refer to the decision of Lord Clark in Rainy Sky and Cookmin Bank, and where perhaps much of the argument may lie, the underlying issue here may be whether commercial common sense simply affects the choice to be made between rival interpretations, or whether it also may affect the identification of those rival interpretations. And what we say one derives from the passage of the judgment of Lord Clark in Rainy Sky, which is cited at paragraph 41 of DNA Nudge, and indeed what one also gets from the judgment of Lord Neuberger in the Re Sigma finance case, is that in the course of an iterative construction, one has regard to the commerciality of competing potential constructions, not simply in choosing between rivals, but in deciding what the rivals are. The second case which I would cite at this stage is the Lemessa case and the speech of the judgment of the then Lord Chancellor Sir Geoffrey Voss in that case. That is in the second volume of the Authorities bundle behind tab 22. It's a case which concerned the circumstances in which an English bank was entitled to refuse to pay interest to a Cypriot bank under a facility agreement in order to comply with sanctions regulations. Sir Geoffrey Voss summarizes the principles of contractual interpretation in a section of his judgment starting at paragraph 18 at page 839 of the bundle. We would draw particular attention first to paragraphs 18, 5 and 6 on page 840. That's between B and D, as the circumstances in which one may properly depart from the natural meaning, assuming that there is a clear natural meaning, and what, as in 6, is the appropriate way to proceed where there are two possible constructions. namely to prefer the construction which is consistent with business common sense. We also would draw attention in particular to the passage at the top of page 843, that is to paragraph 22, little Roman 2, and what's said there about the interests which one has to which one has to have regard, namely that in construing a commercial contract, the court must always take into account the commercial interests of both parties. There are indications in this judgment that the judge was rather more focused on the commercial interests of Synergy than of Lemessa. At paragraph 41 of his judgment in this case, the judge takes account of what he sees as the interests of Dame Zaha. That one sees behind tab 7 in core bundle, the core bundle at 91. We may need to look at that a little bit more precisely later, but what we do say is there is no real equivalent consideration given in the judgment of the of how the license agreement may work from the company's perspective. The company has no right to terminate it. No consideration of the kinds of issue which we have already been considering when we went through the terms of the license agreement itself. It's important also to understand what it is that Sir Geoffrey Voss meant by commercial interests in this context. And in relation to that, if one turns to paragraph 38 of the judgment on page 845, it sees there in his section headed the unitary process, it says the competing interests of the parties to a Tier 2 capital facility agreement, including clause 9.1, the lender's interest in being paid timorously is against the borrower's interest in being able to delay payment if, put broadly, payment would be illegal, not only under English law, but under any system of law, which would affect the borrower's ability to conduct its ordinary business. The interests concerned, the interest that he identifies, is that inherent to the status of the parties under the facility agreement. He is not there speculating about the adequacy of the consideration or any collateral interests that the parties or one or other of the parties might have. And if one turns to paragraph 46 in the same judgment on page 846, one sees how that is comes into play in the conclusion that he then arrives at. Overall, the balance between the interests of the parties to this type of facility agreement and here, having identified that, that is what he is seeking to identify in order to conclude how to construe the terms concerned. Now, I should say that that's the case in which there was some hesitancy on the part of Lord Justice Arnold, who didn't actually give a he did not he did not dissent, but he did express his doubts about that, and that is a question in his judgment as to the extent to which Sir Geoffrey Voss was going beyond what the more natural meaning of the words might support. The approach taken by Sir Geoffrey Voss to the interests of the parties in the Lemessa case chimes, we say, with the approach taken by the courts in the reasonable notice cases such as Martin Baker, Spenborough and Staffordshire, which are in the bundles, and to which I will take my lords briefly. In all these cases, the court was driven to conclude that the agreement was terminable on reasonable notice because it was contrary to commercial common sense for the relevant party to have committed itself to perform the agreement in perpetuity. First, there is the Martin Baker Aircraft Limited and Canadian Flight Equipment case, or in fact, cases, one against the company and one against Mr. Morrison. Mr. Morrison was a former employee of Martin Baker who went to Canada to run the business of Canadian Flight Equipment, which was set up to sell Martin Baker automatic aircraft ejection seats in North America. The case is to be found in the first of the volumes of the authorities behind tab 6 at page 205. It starts at 183. The section that we rely on is at 285. This was an agreement which was silent as to termination. Nonetheless, it's addressed, the issue is addressed as one of construction by Mr. Justice McNair, as one sees in the first full paragraph on that page, where the sidelining is to be found. And one thing that we emphasize is what's taken into account by Justice McNair in coming to his conclusion, in particular on page 207, where he is looking at the commercial consequences of different interpretations. He notes, for example, that and I'm reading now from about 6 lines down in the first full paragraph, the agreement doesn't impose any obligation upon the Canadian company to manufacture, sell or exploit any of the Martin Baker products at all. And he observes some 4 lines further down, that alone appears to me to be a consideration which points quite plainly to the view that Martin Baker cannot have intended that they were to have their hands entirely tied by what may be wholly passive action by the Canadian company. What drives him to conclude that the agreement must be terminable on reasonable notice is a consideration of economic consequences. And one sees the same thing in the later cases. If one goes to Spenborough Corporation and Cook, which is at tab 9, starting at page 332 of the bundle, that's a case concerning an agreement regulating the discharge of trade effluent into the local authority sewers. And the passage I would draw attention to is starting at the bottom of page 339 in the judgment of Mr. Justice Buckley, as he then was. He concludes that the agreement is terminable as a matter of construction, as it would not be commercially sensible to conclude otherwise. the reasoning is of course specific to the facts of the case, but the approach, we say, is a consistent one, and indeed consistent with the third case, which is the Staffordshire Area Health Authority and South Staffordshire Water
I'm
Works.
sorry, Mr. Block, maybe you weren't quoting, but I was hunting for the words commercially sensible. I couldn't see.
I was not
Right
quoting.
page,
I was
that's
not
all.
quoting.
No, so which page was it? 339
It's 339 over to
to
340,
Thank you.
and what's being considered there is the nature and consequences of the relevant obligations under the various agreements, including a comparison with one of the cases that went the other way, which is the Clonelly Railway and Dock Company case, in which there was a very substantial capital commitment by the other party to facilitate the arrangement, which was then subject to the ongoing agreement.
Yes, I'm sorry to be tedious about it, but I don't see a reference to consequences. I'm very happy to be shown it.
I'm sorry.
Since that was your submission, that's what I'm just trying to make sure I've got.
Indeed. Well, the passage that I've highlighted is in the present case, is at F. In the present case, the corporation contend that the nature of the 51 agreement is such the parties could not reasonably taken to have intended that the corporation should be powerless to bring it to an end. And what is considered in the passage that went before is the different circumstances arising in different cases in which the same issue has arisen. But, my lord, I can look in a little bit more detail for...
That's fine, I understand. Thank you.
If I may, Lord, I will come back to that if given a better reference to give you by those behind me, and will refer to one other case at this stage. Mindful, I don't know if my lords were minded to have a break for the transcribers, but
Don't see a particular reason to do so.
in which case, my lord, I proceed directly to Staffordshire Area Health Authority and South Staffordshire. That's the third of these cases I've referred to, and it's behind tab 12 at page 372 of the bundle. It concerned an agreement for the supply of water by a water company to a local authority. It was a unanimous decision, but whilst it was a unanimous decision, the reasons given by Lord Denning differed from those given by Lord Justice Gough, as he then was, and Lord Justice Cumming Bruce preferred the reasons given by Lord Justice Gough.
He was always Lord Justice Gough, wasn't he? This is Reginald Gough, isn't it?
Ah,
Maybe I'm wrong.
my lord is almost certainly right. Sorry, I was confusing him. In this case, there were words to construe, as one sees indeed the first words in the judgment of the Master of the Rolls, Lord Denning, on page 375. 4 simple words: at all times hereafter. And at first instance, the judge held that at all times hereafter meant in perpetuity. Lord Justice Gough acknowledged that in perpetuity might be the prima facie meaning to be given to at all times hereafter. One sees that if one turns to page 385 and the passage between D and E. Here, it seems to me that although the words at all times hereafter do now conclusively and inevitably declare perpetuity, they are a factor to be weighed against the defendants because they are by inference to be cut down so as to mean during the subsistence of the agreement and not forever. So subject to that, Lord Justice Gough nonetheless held that it should be, those words should be construed in a way which meant that the contract was terminable on reasonable notice, given the commercial considerations which he proceeds to consider at page 386 C, where he is looking for a point of distinction with the Clonelly Railway and Dock Company case, which I mentioned. And whilst there are other points that he also makes, I would highlight one to which he attached particular significance. That's at 387F, namely that there was no provision for variation of charges in that case. And we submit that continue indefinitely, the words in clause 12.1 in this case, are just as apt to connote something other than perpetuity as are the words at all times hereafter, and that the commercial case for saying that that's what the parties must have intended is at least as strong. Now, subject to a couple of points which I will endeavour to pick up more specifically in relation to the issues that they arise in the context of the judgment, that was all I was seeking to say at this stage about the general principles. So I was going to then.
If one's looking at whether we're in the territory of construction or implication, you showed us what Mr. Justice Buckley said in Spemborough, and Justice Gough at least seems to endorse that at 1399. Accept the principles laid down by Mr. Justice Buckley. And then there's the quotation of the passage saying it's a matter of construction. Do either Lord Denning or Lord Justice Cumming-Bruce say anything as to whether it's a matter of construction or implication?
Lord, if I just. I mean, Lord Denning approaches it first and foremost as a rule of construction. I'm looking at page 379, and he starts by referring to Gray and Pearson and the golden rule. He quotes the judgment of Mr. Justice Cardozo in the New York Court of Appeals case of Utica City National Bank and Gun at the top of page 1395, and then he refers to the same cases as subsequently referred to by Lord Hoffman in ICS and West Bromwich. He refers to Reardon Smith. I'm not sure actually he refers to Penn and Simmons, but the same line of cases to suggest that construction is no longer confined to the golden rule.
Yes.
He then cites the cases that I've gone to, starting in fact with Clonelly Railway, and then Winter Garden and Martin Baker, etc.
The point is made that those were all cases that contained no provision for determination.
With the exception of this case, sorry, with the last of the cases we're looking at, that is correct. In the case of Staffordshire, there was the question of the interpretation of the words at all times hereafter.
Thank you.
So far as we've looked at Lord Justice Goff,
Lord Justice Cumming Bruce at 1406F, possibly. In regard to the cases, helpfully cite an argument, agree with the analysis of those cases provided by Lord Justice Goff. Can't usefully add anything.
well, that's certainly one place, and that would suggest that there's an alternative view of what's been done here. I mean, part of the difficulty, and I tried in preparing for this appeal to provide myself with a schedule so that one could go through all the ways in which the different words are used. But in some of the judgments, earlier judgments, implied tends to be used, it appears to be being used as a substitute for inferred. In some of the judgments, inferred is actually used, and in some judgments, construction may be being used in the broader sense, in which it was being used by Lord Hoffmann and Belize, and we're told we've got to take care to distinguish in later cases such as Arnold and Britton and the Ustor and Tesco case. So I found some difficulty in developing a submission which said that there was a clear principle laid down by this line of authorities that this is purely a matter of construction. What it does appear to be is a line of cases which is focusing on a special feature of agreements, namely how long they may continue. It could be said in some cases that you need to read something into the agreement to determine that it can be terminated at all, but you could equally say you need to read something into the agreement in order to conclude that it cannot be determined. Determination being, one would say, the natural default position, because nothing goes on forever. But if one looks for the preponderance of the language in these judgments, the approach appears to be, in this case and in the early cases, including, and I haven't gone back to it, the speeches in Winter Garden, that it was a matter of construction, at least in some sense. I was then, subject to any further respects in which I can seek to clarify those submissions, going to say something briefly about the relevant background or factual matrix in this case. And of course, but we would submit the most significant part of the background in this case is perhaps the background as set out in the recitals to the license agreement itself. So one sees those at page 134 of the bundle. The licensor is the owner of the marks. The licensee wishes to use the marks in the territory in relation to the licensed services. Certain aspects of the wider factual matrix are set out by the judge in paragraph 47 at page 92 of the bundle. Sorry, no. Paragraph 45, I apologise. The wider factual matrix, so far as relevant, is likely consistent with this conclusion. I'll come back to the conclusion. At the time of the license agreement, Dame Zaha was sole shareholder in and director of the company. It was also common ground, indeed part of the company's case, that she intended that over time Mr. Schumacher and other members of senior staff would be given equity in the business. In such circumstances, where there was likely over time to be a relinquishing of control at the level of the company, it makes good sense to think Dame Zaha would have wanted to retain other mechanisms of control via the license agreement over the valuable marks, which to some extent embodied and reflected her life's work. It is natural to think that such mechanisms of control included a unilateral right to terminate the company's entitlement to use them. As the judge notes, it was part of the company's case that she intended over time that Mr. Schumacher and other members of staff would be given equity in the business. What follows in 45 is, we'd submit, more speculation than factual matrix. Dame Zaha may well have wanted to retain some mechanism of control over the marks. However, the license agreement contains standard mechanisms of control over the marks. There is no reason to think that she considered such standard mechanisms inadequate. A licensor may well think that it needs to have a mechanism to terminate the license if it's unhappy with the licensee. However, we do not understand why protecting the marks should have required the licensee have no right to terminate the license at any time in any circumstances. Turn then to the language of the clause 12 itself. So that is at page 142, and the particular focus is on clause 12.1, but in the context of the clause in the agreement as a whole. At first we say that as a matter of semantics, the words continue indefinitely are apt to connote something that may not continue infinitely. Second, as a matter of grammar, the statement in clause 12.1 that the license shall continue indefinitely is separated from the rest of clause 12.1 by a comma followed by an unless. As a matter of grammar, the comma followed by the unless indicates that what precedes the comma is to be afforded some independence. And third, of course, there is the use of earlier in the phrase unless terminated earlier. The judge dismissed our submission as to the use of earlier in, I think, paragraph 44 of his judgment as ingenious and metaphysical. However, we submit there is no getting away from the fact that the interpretation adopted by the judge gives no meaning to earlier, and indeed perhaps requires it to be misleading. For termination to take place earlier in certain circumstances, there must be some circumstances in which it might take place later. The company doesn't contend that these semantic and syntactical points are decisive in themselves. We contend simply that these points support the argument that there is more than one meaning to consider.
Perhaps, speaking for myself, I have some difficulty with this argument, and it's perhaps because I'm not understanding it. If indefinitely means forever, which is the case against you,
Yes.
then why is it inapposite to refer to what happens if clause 12.2 or 12.3 are invoked. That is to say, a licence or termination as taking place earlier than forever.
Because
What's wrong with that?
our submission, and it may be one that is not finding favour, is that earlier requires a comparison of different times, and forever is not such a time. So if something's not, unless terminated earlier, means that it might be terminated later.
If it said, and shall continue forever until the crack of doom, unless terminated earlier, in accordance with this clause 12, would that
Well,
involve earlier being misused?
My lord, if it was until the crack of doom, meaning a specific time, depending, then my argument would be different.
None of us know when the crack of doom is.
If by crack of doom one means forever,
Yes.
then we would submit that it is wrong. And one way of approaching it is to say this: if it is not terminable other than under clauses 12.2 and 12.3, then the word earlier is entirely redundant. It would be, it goes on forever unless terminated under clauses 12.2 or 12.3. The term earlier inserted there suggests, we submit, that there is an alternative, because one thing can only be earlier than another.
Right. I think I do understand the argument.
Thank you, Lord. But given the quality of the draftsmanship, the distinction between forever and the crack of doom may not have been in the draftsman's mind. So I accept that there is limited weight that may be put on any one of these particular semantic or syntactical points we make. What we do submit, of course, is that there is sufficient uncertainty that when read together with a consideration of the commercial factors that would have been in the minds or wouldn't be in the minds of a reasonable person in the circumstances in which this agreement was made, one may interpret the agreement and those words in particular in the way that we submit they should be. Now, I was intending to go briefly to the arguments advanced by the Foundation, and to do that by reference to certain points made in the Foundation skeleton argument, starting at page 61 of the bundle at paragraph 10. And I think I can deal with this one quite briefly. The Foundation submits in paragraph 10 that clauses 12.2 and 12.3 provide the licensor with two modes of terminating the license. And it said, so clause 12 provides the licensor with the ability to terminate the agreement, but does not provide for the license to be able to terminate, the licensee to be able to terminate the agreement. A separate unilateral right to terminate for breach would be expected in any event. So that doesn't support the Foundation's construction. Clause 12.2 gives the licensor a right to terminate on 3 months' notice. I've got them the right way around. This may provide some slight support for the Foundation's construction. However, it is readily understandable that the licensor should wish to have clarity as to the maximum notice which it might be required to give. The licensor might argue that reasonable notice was less than 3 months. If, for example, the licensee ceased to use the marks, so it would still benefit from there being a reasonable notice provision, but it would at the same time know with certainty that if it wanted to be shot of the licensee without cause, the maximum time it would have to allow would be 3 months.
That assumes that failure to use the marks wouldn't be a material breach.
Well, it not so much assumes with respect that it wouldn't be a material breach, it just provides a quicker route than arguing about it. So you have an absolute right without cause, you don't have to prove a cause. And if you're concerned to be able to act without challenge, that would be the simplest route through.
Could we look at 12.3D just in passing? This is one of the remedies available to the licensor to terminate by written notice.
Yes.
And it's exercisable insolvency resolution for winding up. In fact, other than voluntary. I'm not sure if that's really what was intended, but how if at all does this play into the discussion that we had earlier about what happened if you simply wind the company up?
Well, the prior discussion was focusing on whether or not we could properly do that.
Yes.
What clause 12.3D is concerned with is the rights of the licensor in circumstances where we have done it properly or otherwise. It could be that we can't properly do it, having regard to the proper construction of, among other things, clause 5.1, but that we nonetheless do it, leaving aside any question as to whether we could be injuncted from doing it, depending presumably on the circumstances and the arguments about whether or not specific performance would be available. There potentially would be a right for the licensor to terminate the agreement and then seek damages.
This applies for an immediate termination. These are circumstances in which, curiously, a voluntary resolution to wind the company up would not give right to immediate termination rights in the same way as insolvency.
My Lord,
Funnily enough,
Absolutely. I mean, these are quite. This is quite a common termination for cause, and it would enable the licensor, the moment there's a petition to wind up, to say, I don't want my mark being associated with an insolvent company.
Yes. So, but if it was voluntary, you have to give
I can take away, but I'm not enabled to do that if it's simply a solvent reconstruction, which isn't going to have any adverse effect on the reputation of the mark, let us say. I mean, these are not. I think you characterise these as termination for breach in 12.3, but they're not all termination for breach. If you take 12.3a, non-payment of any amount due under the agreement, probably not necessarily be a regulatory breach. But the licensor still might want to make sure that it can terminate on 3 months' notice in any event if there is constant late payment and constantly having to chase with a default notice under 12.3a, for example.
Lord, yes.
I mean, the boilerplate nature of 12.3d may be thought to be obvious from the fact that it refers to a manufacturer and not just mine.
Yes, I mean, and indeed, I may not have heard what Lord Chancellor's observation was, but it's a defined term, yes. So, but it's a defined term in D, but I don't believe it's,
Obviously, it's got a capital letter there. I don't think it's.
yes, but I don't believe it's a defined term of the
My
agreement.
Lord said that's an indication that it's obviously a boilerplate term that's been lifted from somewhere else without any
Yes.
careful thought to tailor it
Yes,
to this agreement.
but the principal point that I seek to make here is that there is no inconsistency, particularly in a case as this, where the agreement has been drafted somewhat inelegantly, employing boilerplate, and by the lawyers on behalf of one party, in finding some degree of overlap in the rights afforded to that party. So the fact that the agreement affords one of the parties a belt doesn't mean that it can't afford both parties a pair of braces as well. What we have here is a series of provisions which may well have been built up cumulative without any enormous thought given to the avoidance of overlap or maximum efficiency. But
I think your case is, tell me if I'm wrong, that from the licensor's point of view, a term that it could terminate on reasonable notice might not just be belt and braces, because there might be some circumstances in which the reasonable period would be less than 3 months.
My Lord, yes, precisely. And so far as the way in which this has been built up, if one starts from the perspective that clause 12.1 provides for reasonable notice, the licensor may be saying, well, is that going to be good enough for me? And they say, well, I'd also like to have on top of that, obviously, a right to terminate in the event of breach or particular circumstances if it were thought through, such as 12.3d. And then, well, what happens if they stop using the mark? And you say, yes, well, in that situation, reasonable notice may actually be quicker, but we still want to know that there's a maximum time, and let's put in 3 months. So it's readily understandable that one should have a tier of provisions of this kind. In paragraph 11 of their submission, the Foundation submits that the fact the license agreement is a detailed and professionally drafted agreement means it's beyond argument that clause 12.1 would have set out any right to terminate on reasonable notice more clearly. I think we've been considering quite how carefully and professionally the agreement has been drafted, and my Lords will appreciate that the judge himself in this case observed at paragraph 44 that clause 12.1 is perhaps somewhat inelegantly expressed. In paragraph 12, that's I think also still on page 61 of the agreement, the Foundation submits that clause 12 should be a complete statement of the available modes of termination, subject to the points that were raised in relation to implied terms at the outset of our submission. We accept that. The question is, what are the available modes of termination in clause 12? And one comes then to commercial considerations, and to a considerable extent, those have already been aired. First, we must consider the commerciality of the license agreement being terminable on reasonable notice. This is a perfectly normal commercial arrangement. Agreements which are terminable on reasonable notice may continue indefinitely, and there is no reason why the license agreement should not have continued indefinitely, at least as long as Dame Zaha was alive and an association with her architectural style was valuable to the company's practice. Second, we must consider the commerciality of the license agreement not being terminable by the licensee in any circumstances ever. And first we observe the license agreement threatens to operate as a poison pill as it applies to any and all services conducted by any and all group companies anywhere in the world. It means that royalties would be payable on the total revenues of any business that acquired the company and on the total revenues of any subsidiary or affiliate business of the company. And we say no sensible business would accept such a burden in perpetuity. Second,
if it's a burden that they've accepted for so long as the agreement continues, why would they not accept it in perpetuity if it only continues for as long as the right to exploit the marks continues? If you're looking at the payment aspect of it, what's uncommercial about agreeing to pay forever for so long as there is an ability to exploit the marks?
there will be I'm maybe misunderstanding the question, but as as we put it, or would put it, so long as the agreement is in place, we are obliged to pay royalties on all licensed services, including those of any group companies, whether or not under the marks.
Yes.
And that means that during the pendency of the agreement, there are certain things which it would not make commercial sense to do. It wouldn't make commercial sense to merge with a company that wasn't using the marks. It wouldn't make commercial sense to acquire a business that wasn't using the marks. That restriction on one's ability to conduct your business as one chooses may well be acceptable whilst the marks are being exploited and the license is regarded as commercially worthwhile. But to accept that restriction in perpetuity is a quite different thing, because that is saying that you are excluding for all time the possibility of doing these things, save at a cost which is almost certainly or could very well be preclusive. Does that answer my Lord's question, or have I misunderstood the question?
I think it answers it, yes, thank you.
Well, I'm grateful. So first of all, there's the poison pill. Secondly, there is clause 5.1 and the implications of that again for the business going forward, both the business of the company and indeed any group companies, should the architects of the firm at any stage wish to consider confining their business to Western Europe or focusing on a particular niche kind of architecture which is of interest to them, rather than pursuing a maximist expansionist position, they are precluded. That again may not be a problem if one simply focusing on such period as one is obliged to take that course with the option of terminating in due course. But it is a problem, we say, and an obvious problem, such as to make no commercial sense if if the license agreement has been interpreted in such a way that that would be a commitment to expand, to keep one's leg on the accelerator in perpetuity.
Why is the solution to that problem not what I'm going to call a sensible interpretation of clause 5.1 rather than a maximalist interpretation of clause 5.1 to read something which is on the hypothesis that your submission is it's uncommercial. Just because that's your submission, the solution to that uncommerciality is to not read the obligation you're referring to, the maximalist obligation, to be quite so maximalist. It's a reasonable degree of maximalism rather than a silly degree of maximalism.
Well, my lord, responding to my lord's question obviously puts me in a slightly difficult position, because I don't want to respond by saying that the words of that kind can't possibly bear any meaning but the one that I attribute to it, because if it makes commercial sense, then the thrust of my argument is that the court should be open to such a construction. But if one looks at the language of the clause, first it's best endeavours rather than reasonable endeavours, and there's some legal meaning to be attributed to that. And then the language is on the maximum possible scale.
Yeah.
And
Why wouldn't someone who was happily using a mark and it was their business want to expand their business to a maximum possible scale?
well, in what this is, not simply expand its maximum possible scale, and in relation to all of the licensed services, but also the advertising and publicity to reach as many purchasers and potential purchasers as possible. That provision, even if read purposively and looking for a reasonable interpretation, would be hard to reconcile, for example, with a decision within the firm to focus on a particular kind of architecture of interest to the partners. It's difficult to reconcile, and not impossible to reconcile, with a firm that decided that out of concern for the well-being of its partners and staff, it wishes to focus on business in the UK exclusively, or in a particular part of the territory, in order to afford, with compliance with that clause, the sort of control that a company would reasonably be expected to wish to have over the conduct of its business, if thinking in terms of perpetuity, one would deprive it, we would submit, of any real meaning.
Okay.
So I was going to go through the particular grounds that we have identified as points of error in the judgment, but I believe we have touched on most, if not all of them. So if I may, I'll just quickly look at my note to see what further I need to deal with. Yes, in relation to ground one, which is concerned with the judge's approach to interpretation of the licence generally, the judge notes at paragraph 55 on page 94 that the company has traded successfully under the licence agreement for several years, picking up really on what we were considering a moment ago. What he does not consider is the commercial consequences of the company of being tied to the licence agreement in perpetuity. And at paragraph 45, as I think we've seen, the judge looks at the matter from Dame Zaha's perspective. He states what is natural to think she would require. He doesn't conduct a similar exercise from the perspective of the company. So far as ground 2 is concerned, paragraph 44, so we're on page 92. He says that it makes no real sense to look at the clause in isolation. I think the issues that arise in relation to that I have already addressed. In fact, it goes a bit further. He says in 44, about 2/3 of the way down, to put it straightforwardly, in express terms, the remainder of clause 12 seemed to me flatly inconsistent with the construction that the company seeks to put on the first part of clause 12.1. Inconsistent is a word capable of bearing more than one meaning itself, of course. There's nothing contradictory about what we are advocating, and you have my submissions as to why the draftsman should have employed the sort of overlapping approach that we see in clause 12. The third ground focuses in particular on the Martin Baker line of cases. It's concerned with the judge's failure to have regard to the way in which the commerciality of in perpetuity constructions has been approached in such cases. He refers at, I think, paragraphs 36 and 43 to Martin Baker and that line of cases, but it does not draw or attempt to draw anything from them. Overall, I think the approach that the judge takes to the construction of the agreement seems to have been, we say, disproportionately influenced by a focus on what he, in some cases, is merely speculating. Dame Zaha might have wished, that there is a failure to consider the commerciality of the matter from the perspective of the company. Now, subject to any further questions that I should address at this stage, and mindful of the indication from the Lord Chancellor that you would wish to progress this matter as quickly as we can, and subject obviously to maintaining the position that we have in our skeleton argument, and that was all at this stage that I was seeking to say in relation to interpretation.
I've got one small question on the contract I should have asked earlier. But in paragraph, in clause 3.7, which is on page 137, there's a reference to the licensor being able to delete any of the entries set out in Schedule 2. I don't think there is a Schedule 2. Is that a mistake for Schedule 1?
I think, and I'll be corrected.
Was there a Schedule 2?
I'll be corrected if I'm wrong. I'm not aware of us having seen a Schedule 2.
The only reason I thought there might not be a Schedule 2 is that Schedule 1 starts with an internal page 14, and the agreement then runs through to internal 17, and then there's an internal 18 which contains the signature. But I may be wrong, which is why I'm asking the question.
I'm getting an indication, at least from those behind me, that there isn't a Schedule 2. It, no doubt, something we can pursue. It would appear to be just another indication of a slightly loose drafting or loose use of some boilerplate, or perhaps an intention to have added something which was never actually done. It is noted by the judge that the license was, the trademarks were being used by the company prior to the agreement without a license, and the license was entered into in order to provide a means of income to Dame Zaha in circumstances where there had been some unwelcome interest in her finances in the press, and she wished to be able to have a income which would be both regular and discreet. But I think the answer to the question is there wasn't one, but I'm loath to give evidence and I'm not certain. I move on then to the second issue, which is restraint, and what may be the principal issue in relation to that, which is at issue in this case, namely, what counts as a restraint for the purposes of the restraint of trade doctrine. And the starting point, we say, is so one can derive from the speech of Lord Parker of Waddington in the Privy Council in Adelaide Steamship Company, which is the first of the authorities in volume 1 of the authorities bundle, starting at page 3. It in fact is a case concerned with the construction of a novel statutory competition, a novel competition law statute, but the off-cited passage from the judgment delivered by Lord Parker is as to how the law existed or exists prior to the statute, and one sees that at page 15 in the sidelined passage beginning at common law. Every member of the community is entitled to carry on any trade or business he chooses, and in such manner as he thinks most desirable in his own interests, and inasmuch as every right connotes an obligation, no one can lawfully interfere with another in the free exercise of his trade or business, unless there exists some just cause or excuse for such interference. The observations of Lord Parker of Waddington in the Adelaide Steamship case are then cited in a number of cases, cited by Lord Justice Diplock, as he then was, in the Petrofina, Great Britain and Martin case. That is at tab 7 in the same bundle, but for these purposes, I think one simply goes, it may be helpful to go simply to page 234B, and what's stated there in the section between B and D. Petrofina is a solus agreement case in which the garage owner covenanted to purchase his fuel from Petrofina. He also covenanted to keep the garage open at all reasonable times. I'll take the Lord's in a moment to what the court said about that. And also he covenanted to sell the garage to someone who would covenant with Petrofina to the same effect. The passage we rely on for immediate purposes is B to D on page 234, and one sees the line of authority on which that is based. The same line of authority is then picked up in Esso Petroleum and Harper, in particular in the speech of Lord Wilberforce, who cites both Lord Parker in Adelaide and Lord Justice Diplock in Petrofina, the relevant section of...
The bit of Petrofini you gave us says Lord Denning.
Yes.
Sorry, I've given my lords the wrong reference there. The reference I intended to give you was not to, I mean, Lord Denning does say something to the same effect, but that was not the passage that I intended to.
Unless I missed it, I thought you said page 234, which is...
And I did, I gave the wrong reference. It's 245, which I also should have given to the same effect, but in the judgment of Lord Justice Diplock. And that's where he expressly cites the Adelaide steamship company case, and then later the passage or the speech of Lord Macnaghten in Nordenfeld, which is picked up in particular in the George Michael case, to which I will go in a moment. With apologies for that misreference in relation to Petrofina, I was going to go to the speech, or I was going to the speech of Lord Wilberforce in Esso. I'm very aware that to some extent one does it in this way. One's offering sound bites, and there still remains a question as to quite what the court had in mind. But it is, I would submit, a powerful starting point that these statements are made with the utmost generality as to the nature of the free trade that they are seeking to protect. Now, Esso was another of the Garage Solus cases. It is, of course, the subject of consideration in the more recent case of Peninsula, and so far as the law in relation to the approach to be taken to in assessing restraint of trade, it was the minority or the dissenting or different approach, not strictly dissenting, of Lord Wilberforce in Esso, which is adopted in Peninsula. For immediate purposes, however, that's not really the issue. We're immediately concerned with the distinction, with the nature of the restraint, rather than the ways in which one may distinguish those circumstances in which it is necessary to consider the application of the restraint of trade doctrine, and those in which one may dispense with the need to assess the reasonableness of a restraint of trade. The key passage for these purposes is on page 819 in the speech of Lord Wilberforce.
319.
Sorry, 319. 319. At B to D, again, of making the points that are oft made, that doctrine of restraint of trade is a doctrine which has been expressed with considerable generality, if not ambiguity. It refers to the cases I just referred to, Nordenfeld, Adelaide and Petrofina, and to the concept of the right to have a free exercise of one's trade. And then at the bottom of that paragraph, and the point we do emphasize, is the last sentence: the doctrine of restraint of trade is one to be applied to factual situations with a broad and flexible rule of reason. We accept, and of course, it's something which appears to have been very much in the judge's mind in this case, that restraint of trade, or the restraint of trade doctrine, is not directed to affording relief from unfair or unconscionable bargains. The different approach of equity in the common law are explained in the judgment of Mr. Justice Parker in the Vanuatu case, and I'm not sure that it's necessary for me to go to that, but I will give my lords the references. Vanuatu, of course, is the family name of the musician George Michael, and in what is a very extensive analysis of the law in that case, Justice Jonathan Parker explains the free trade foundation of restraint of trade doctrine and how it is distinguished and has been distinguished over the years from the equitable doctrine in a passage at pages 480 and 481 of the bundle. Indeed, I think attributing the free trade approach and its development to, among other things, Benthamism and utilitarianism, but it may not be necessary to go into that. What we must acknowledge is that this case is not a familiar, or the restraint in this case is not one of a kind which one sees in the restraint of trade cases that we've gone to or might go to in the authorities. The license agreement is not an employment contract. It doesn't relate to the sale of a business. It's not a solus agreement. It doesn't restrict the use of premises, and it doesn't oblige the company to sell its products to a particular buyer. Indeed, it does not expressly prohibit the company from trading with anyone, and of course it doesn't impose any post-contractual restraint on the company, at least on the construction that we are concerned with when considering restraint of trade. Joseph Heller, the author of Catch-22, might appreciate the irony here. The mischief in this case, on the hypothesis on which we're operating, is that there is no post-contractual period on which any such constraint might bite. The judge summed up the position somewhat dismissively at paragraph 69 of his judgment, at page 97 of the bundle. He states there all the company, now I'm reading the last sentence, all the company says this is prevented from doing is possibly managing its very successful business in a different way, but to my mind, that's not enough. On the dicta of Adelaide, Nordenfeld, Petrofina, Esso Vanuatu, we would say that what the judge describes, namely being prevented from managing one's business in a different way, is a restraint of trade. It's unclear how much significance the judge attached to the fact that the company had been very successful. He notes it. The fact that the business has been successful to date is, we submit, of little, if any, significance. First of all, for reasons addressed by Lady Justice Arden in the Proactive Sports Management and Rooney case, and secondly, having a regard to the assumption we have to make here as to perpetuity. So far as...
I don't know if you finished on the law, but can I put to you one piece of what I thought the law was, which you haven't mentioned, which bears on what you're just submitting, and maybe you're going to come back to it, and that's fine if you are. My understanding of the law in this context is that the fact that a contract or a clause can be understood to represent, and I'm going to deliberately use the word fetter, a fetter on a company or anyone, on someone's ability to conduct business, and again I'm deliberately using that word, that fact, while it might be a necessary precursor to engaging the doctrine of restraint of trade and therefore the requirement to prove reasonableness, is not enough. You can find things which are fetters on business, but that isn't enough to say that the doctrine of restraint of trade, which requires you to prove reasonableness, is engaged. That's what I understand the law to be.
My lord, yes. And
so merely to identify that a contract contains a fetter on a business is important, it's critical, you have to prove it, but it's not the same thing as saying that once I've shown there is a fetter on business, haha, I win, I've shown there's a restraint of trade.
my lord, certainly, and I will come back to that.
Fine.
But again, maybe I should just foreshadow it. Yeah, there is a sense in which, and one sees it observed in the authorities, almost any contract includes an element of restraint insofar as the parties will be obliged to perform their obligations under the contract, and that may preclude them from doing other things. So in that sense, any obligation restrains you so far as you're then obliged to comply with it. Dealing with it in the round and then more specifically, the focus in the part of the judge's judgment that I'm introducing and intending to go to more closely in a moment is concerned with really how much consideration one needs to give to the matter at all. Is this the sort of obligation which, and I'm going to deliberately use the term loosely, engages the doctrine in any sense? Now, when one actually looks at the argument in a bit more detail, one sees that what's being discussed by Lord Wilberforce in the Esso case is those cases or those agreements where one can dispense with the need to consider the restraint from the perspective of reasonableness. It is, and I'll go on to submit, a form of triaging. Lord Wilberforce says two things, which I'd focus on at this stage in answer to my Lord's question. First of all, that there are certain kinds of contract where generally one can dispense with the need. Those which satisfy the trading society test, we're all familiar with them, as he might have put it. But secondly, he goes on and says that even in relation to those types of agreement, of which we will acknowledge license agreements, trademark license agreements, are a category or categories, there will be examples, or there may be examples, which have special features or are exorbitant in certain respects, where you can't dispense with the need to test them from the perspective of reasonableness. And one thing I'll need to look at a little bit more closely after the short adjournment is what is said about this by Lady Justice Carr, as she then was in the quantum advisory and quantum actuarial case, and the significance that the judge appears to have attached to the way in which she dealt or approached the first of the two stages set out by Lord Wilberforce in Esso, namely what she says about the 3 steps that she adopts for convenience. And the reason why that may matter, we submit, is because it is, it would appear to explain and is certainly consistent with the judge's failure, as we submit, to consider the commercial consequences to the company, to the licensee, of the restraint, which he dismisses as not being a meaningful restraint for these purposes. So that's a very long-winded way of saying yes to my Lord's question.
Okay.
The next point that I was going to go on to was, as I said, in relation to the significance of commercial success and what's said by Lady Justice Arden in the proactive sports management and Rooney case. And if there is time just to go to that, one finds that in the first bundle of authorities behind tab 16, page 621. The case relates to the terms of an image rights agreement between Mr. Wayne Rooney and the agents appointed to exploit them, I think in that case by his parents. They just articulates the policy underlying the doctrine at paragraph 93 on page 645. I'm thinking particularly in the second sentence, the public policy is concerned with the manner in which the person may properly realise its potential not only for the good of the individual, but for the economic benefit of society generally. There was an issue there as to whether or not trade included ancillary trade. So I don't think there's any issue in this case that, in fact, the restraint of trade doctrine may apply to any business or commercial activity. At 99 on page 646, it's a note the reasons why it was thought that the doctrine was engaged or potentially engaged in that case, which was the special features, and in particular the unusual length of the contract, and then perhaps more pertinently for immediate purposes at paragraph 104, at the bottom of that same page 646, Lady Justice Arden addresses the question of financial success. It's no answer to say there's been substantial financial rewards on all sides from the exploitation of the images. The question of restraint of trade is to be considered by reference to the terms of the agreement, and then she goes on to expand on that. So one looks at it by reference to the terms, and one looks at it as at the date of the agreement. In any event, of course, even if some importance might be attached to commercial success in other contexts, given that the restraint in this case may continue in perpetuity, a 9 or 10 years success is, we would argue, neither here nor there anyway, because one has to have regard to its consequences, not simply over the first 10 years, but over a far longer period. And if that would be a convenient point, I think I'm moving on to a separate topic.
Very well. Let's rise. We'll sit again at 2 o'clock.
Court rise, if able.